these issues quite well. We've got a lot of interesting issues to actually cover. A couple of things that I will be looking at is we already have a question, so I won't really, say much on it because I'm sure there are a lot of interesting things that will keep on happening throughout the conversation. But Keshavji, if you can start, we'll be able to,
Yes, absolutely. So I think YouTube stream has also started. So I'll just do this. Right. So hello and welcome everyone. Wish you a very good evening. We are with you again on this Monday evening today. We welcome you all and we are thankful to you for sparing time, and we hope that this session and this initiative is helpful to you. Again, I want to just remind everyone that this is a free legal literacy initiative and it's only possible through the kind support of our seniors, their blessings, and all of our colleagues at the bar who take time out to educate us on various topics of law. Today, we have with us one such legal luminary and one very bright lawyer whom I am actually looking forward to how his career graph also progresses, because so far what he has done, I think it's absolutely exciting. And I again take this opportunity to introduce you to Mr. Aditya Ajgaonkar. He's an advocate from Mumbai. He is a legal counsel practicing in the fields of corporate laws, including taxation, and in the field of laws relating to economic offences. He has been working with and has been mentored by some of the leading lights in legal fraternity after graduating from NM College in Mumbai. Uh, and doing his law from Mumbai University, he has studied his LLM at Cardiff University in Wales, where he wrote his dissertation on the law of money laundering. This was to be the start of his long-standing love for his favorite subject, the laws relating to money laundering. His book, Investigation, Confiscation, and Prosecutions under the Prevention of Money Laundering Act, has been published in 2003 by Taxman Publications and has seen wide circulation across the country. While he currently assists senior advocate Mr. Vikram Nankani, in the past he has read law in the chambers of leading luminaries in the field of law, like former judge of Honorable Delhi High Court, senior advocate Mr. R.V. Iswar, senior advocate Mr. K. Shivram, senior advocate Mr. Sailesh Shah, and advocate Sudeep Pasbola. With this, Mr. Ajgaonkar, we very warmly welcome you. We are grateful to you for taking time out on this Monday evening, and we're very excited to learn more about you and through your experiences of what law around money laundering actually are and where they stand today. So we welcome you, and we request you to kindly take the class forward.
Firstly, I'd like to thank the team for having such an excellent initiative. I think it is the need of the hour. A lot of judges, a lot of lawyers keep saying how important it is that continuing education be made available not only for other professions like chartered accountants, but also advocates. And I think this is a fantastic, sort of an initiative, and it's quite brilliant because it's been taken by a private entity. So I need to congratulate you for that. I know it probably takes up a lot of your time and effort also in addition to your own practice. So before I do anything else, I'd really like to appreciate the effort that you and your team have been putting in, and kudos to you for that. Good evening, everyone. It's such a pleasure to have you all here on a Monday evening. I'm sure it wasn't easy getting away from the regular hustle bustle of Monday evening. But I think rather than me, which very few of you all might be knowing, if at all, you all are actually here for PMLA, which everyone's heard about. Anyone who's been reading a newspaper recently, anyone who's been living under a rock actually even today, seems to have heard of the PMLA. It's a very current topic. Before I deep dive into the swimming pool that PMLA is at our on our limited time frame, because it's actually a sea. If you go to look at it, there are new judgments that come up every day. If anyone's been following the jurisprudence around PMLA, it was very interesting because Justice Bakru actually gave me a message for my book, and when I went back to present the book to him, Justice Bakru said, "Young man, is this book even current anymore?" And this was within a period of 2 months. So PMLA is a very dynamic field. It's moving at a rapid pace because the Directorate of Enforcement, or as everyone knows it, the ED, it has been, at hammers and tongs taking actions all over the country. Before we get into the nitty-gritties of the Indian PMLA, there are a few things that we need to, have a background of. They might not help our day-to-day practices, but they will help in case you have to, actually uh, figure out how to approach a PMLA case in a higher court rather than a trial court. Uh, there is a group of countries that have formed under the aegis of the UN a Financial Action Task Force, which is also called as FATF. This FATF has come out with 40 recommendations, which have to be adopted by its member nations. India is a part of FATF. So even if you go to see the 2002 Act as it originally was, even before all these amendments that have come in, it's very interesting because the preamble itself says that this act has been enacted so as to make sure India is in line with its international commitments. I will be taking you all through the act again and again because a law lecture is completely pointless without a law book in hand. So I have the Bare Act in hand. So all of you all should be able to follow fairly easily what I'm going to say, right? So if anyone looks at the preamble even before Section 1, there is a reference to the political declaration by the UN General Assembly. There is political declaration, global program of action with respect to the United Nations. So we need to stop looking at the PMLA as a local issue. It is a global, issue that has happened. And interestingly, and you will understand, perhaps the full import of this in a bit because the jurisprudence is still evolving. The PMLA, to a large extent, was very highly influenced by America's war on drugs. If you all know, a couple of decades back, the US went all out on its war on drugs. And if anyone out here watches Netflix, and if anyone's watched Narcos, will realize that they showed how fields and fields, in certain countries were full of cash that were buried under the earth, right? The basic concept behind the Prevention of Money Laundering Act is that if you take away, the incentive that is there behind a person committing a crime itself should reduce, right? You know how we say cheaters never prosper. The idea behind PMLA is to make sure those who actually commit economic offenses do not prosper, right? We will be going into the nitty-gritties of the questions. What usually happens is if I take a couple of pauses, it's probably because I'll be looking into the questions themselves. But I would like it if I had a good 10-15 minutes at the start to actually give you all, an idea about the overview of the PMLA and the basic sections that we are talking about. The basic sections, the most important one is Section 3. And as in any other act, Section 2, which is, definitions. Section 3 of the PMLA defines money laundering. And this is a very interesting definition, if you ask me. The reason why Section 3 is very interesting is because, according to me, it is extremely wide, right? I'm going to be reading, and if anyone has anything that they would like to actually contribute to, you all can, join in out here. So the offense of money laundering says, whosoever directly or indirectly, attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering, right? If you all have read this along with me, you all will realize that this seems to, pretty much cover every activity that could possibly be associated with anything, right? So directly, indirectly, attempts to indulge, doesn't even indulge, but even attempts to indulge, or knowingly assists, or knowingly is a party, or is actually involved in any process or activity connected with the proceeds of crime. It doesn't need to be that you actually handle the proceeds of crime. It could be any activity connected to the proceeds of crime, which would include its concealment, possession, acquisition, or use. So concealment is, of course, post facto, once proceeds of crime actually come, into being, if you try to hide it. Possession, if you are in the possession of proceeds of crime. Acquisition, if you try to acquire proceeds of crime. or use and projecting or claiming it as untainted property. That is, if you try to layer it and integrate it back into the system and you claim it as untainted property, you shall be guilty of the offense of money laundering. This is followed by an explanation which says, for removal of doubts, it is hereby clarified that, and then they pretty much almost repeat the entire definition again, the same. A person shall be guilty of the offense of money laundering if such a person is found to have directly or indirectly attempted to indulge, or knowingly assisted, or knowingly is a party, or is actually involved in one or more of the following processes or activities connected with proceeds of crime, namely concealment, possession, acquisition, use, or projecting as untainted property, or claiming as untainted property in any manner whatsoever. More interestingly, it also says the process or activity connected with the proceeds of crime is a continuing activity and continues till such time is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. I'm sorry if the definition seemed a bit verbose. The entire point of reading the definition was that if I read this definition, it covers everything. I struggle to find anything in this definition that if someone wanted to accuse you of the offense of money laundering, and if there was, say, a credit in your bank account, where money came in through a source that was tainted, or suppose a UPI transaction comes to you from a friend, right? He's just returning a loan. Maybe, before you know it, that money might have come from some source that is not so savory. Can you be accused of the offense of money laundering? Accused? Yes, sure. Will you be guilty of it? That is where mens rea comes into the picture. So the only saving grace in this definition, according to me, is the existence of mens rea, right? Because again and again, they say knowingly assists, knowingly is a party, or attempts to indulge. Now, all these things signify the presence of an intention to do the activity that is envisaged by this section. And this, according to me, is pretty much the only safeguard that you have with respect to Section 3, your mental intent, right? Considering that it is so wide, and if I actually go to the fact that, it is very interesting because I already have a lot of, there's already a question with respect to interplay of IBC, right? And a lot of other interesting issues that are already open, even right now. There are various high court judgments that have shed a lot of light on the subject. But I'm sure anyone in the audience who's come here who has even a brief background of PMLA has heard about Vijay Madan Lal Chaudhary judgment of the Supreme Court. Very recently, there was a little bit of buzz around it because the review was taken up by the Supreme Court and nothing came of it. And it will possibly come up again when a new bench is constituted. But the Vijay Madan Lal Chaudhary judgment is perhaps as instructive as the Bare Act when it comes to PMLA, because it has pretty much examined the entire scheme of the Act with the two things that you all tell me are the most interesting to you. A, the confiscation of property that is tainted. B, the prosecution for PMLA. But, we tend to look at PMLA as a very, local issue. We look at like, hey, you know what, only high profile people get prosecuted under PMLA. Where is the chance of me actually getting a client, where I need to actually bother, if I'm a smaller practitioner, to understand PMLA? I've got good news. Not for clients necessarily, but at least for the legal practitioners and the law students out there. PMLA possesses extremely lucrative practice area for people, because not only does it have civil proceedings in the form of attachment and then ultimately confiscation and the prosecution, but also a large area of compliance, which is in Chapter 4 of PMLA. And the compliance section has also seen an uptick very recently, because there were a few notifications that came out in May and one before that, where there is a concept of reporting entities. And these reporting entities regularly, just like your banks have to, collect your KYC details, these reporting entities also have to do KYC and report suspicious transactions to a body called FIUIND, that's Financial Intelligence Unit India, which is basically the nodal agency for collecting intelligence with respect to financial transactions, not the Directorate of Enforcement. There are strict penalties for not complying with the compliance provisions. the good thing is obviously for the clients that there is no prosecution for non-compliance, but there are very steep fines which may extend to almost a lakh per infraction. And it's very interesting because these aspects, the compliance aspect, is something that will go on for big banks. If you see, banks are also regularly adding to their compliance teams. A lot of financial institutions are adding to their compliance teams. Non-banking financial institutions are adding to their compliance teams. In fact, you will see even real estate agents, jewelers, etc., in due course of time add to their compliance team, because this is again mandated by the FATF. There are 40 recommendations that are there on the FATF website if anyone's interested. And that is the intelligence gathering aspect of the PMLA, which honestly isn't that very well spoken about, because there's no glamour in it. The glamour is all in the offense of money laundering, which we started out with. The punishment for money laundering is quite interesting because there are two different punishments that are there. First is your regular punishment for money laundering, which is that if you commit the offense of money laundering, you'll be punishable with rigorous imprisonment for a term that shall not be less than 3 years, but which may extend to 7 years and also be liable for a fine. So punishment maximum 7 years, fine. Your property will also get confiscated, of course. So I don't know where you'll pay that fine from. But interestingly, as I said, PMLA has a genesis from the war on drugs, right, in the US. So, because that is the global framework, and because drugs are such a massive problem and still are even today in the global scheme of things, there is a proviso which says that provided that where the provisions of the proceeds of crime involved in money laundering relate to any offense specified under paragraph 2 or part A of the schedule, the provisions of this section shall have effect as if for the words which may extend to 7 years, which may extend, other words, which may extend to 10 years have been substituted. So in case of the other schedule that they're talking about, which is your schedule, paragraph 2 or part A of the schedule, right? There is the maximum punishment actually goes up to 10 years. And that is where you find your NDPS offense, right? So it's very interesting because the entire scheme of war on drugs is also followed out here in our PMLA. Moving on from here, right, we go to the most important aspect, because if you'll heard the definition of the offense of money laundering, the word that we really need to focus on is the term proceeds of crime. And proceeds of crime is fascinating because it is extremely wide in nature, right? Proceeds of crime is defined under Section 2U of the Act, right? Section 2U of the Act says the proceeds of crime is any property derived or obtained. Again, we go back to Section 3 definition, directly or indirectly by any person, right? As a result of criminal activity relating to a scheduled offense, or the face value of such property, or the value of such property for where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. If you see, there's a waterfall mechanism for understanding the crime of money laundering also, because you have Section 3, which defines the offense of money laundering. Then you have Section 2U, which defines proceeds of crime. And after that, you will also have to go to the definition of scheduled offense, which is in Section 2(1)(y) of the Act. And why is all this important? It is important because Vijay Madan Lal Chaudhary, which we will get to in just a minute. So the basics that we need is, for the offense of money laundering, you need proceeds of crime. For proceeds of crime, as read in this Act, what you need is a scheduled offense to actually have occurred. And scheduled offense is defined in the Act as to being one of the offenses that are listed in the schedule to the Act, very obviously. Therefore, Vijay Madan Lal Chaudhary says that you need the existence of a scheduled offense for PMLA prosecutions under Section 3 or any sort of proceeding. So the long and short is, though Section 3 itself doesn't say so explicitly, if there is no scheduled offense, there is no proceeds of crime. This has also been upheld very recently by the Supreme Court, but we'll get to that in a bit, right? There is obviously an explanation also to proceeds of crime. It says, for removal of doubts, it is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to a scheduled offense. Again, scheduled offense. We will see recurrent themes out here. Whenever we look at section 3, it will refer to proceeds of crime. Whenever we refer to proceeds of crime redirects you to scheduled offense. And this is very important because the scheduled offense is not in the hands of the Directorate of Enforcement. Very often what happens is, the words predicate offense is usually used for the scheduled offense. So people say, the existence of a predicate offense has happened, therefore PMLA has been, invoked. What I usually find is that because I wrote my dissertation on money laundering around 10 years back, I've always viewed PMLA as a predicate offense, right? The primary offense is the very offense which you commit, which is taken cognizance of by the requisite authority. If it's a cognizable offense, then the police will take cognizance of it. If not, the court will take cognizance of it. And then subsequently, only if that cognizance is taken, then and only then can PMLA proceedings be taken out by the ED. The ED's hands are extremely, extremely powerful with respect to PMLA. A lot of power has been given to them. The courts have also held that there are sufficient checks and balances that have been put in the hand, to tie the hands of the ED to make them accountable. Whether that is or not is, it's not our wisdom to actually, figure out. Everyone can have their own opinion about it, but there are inherent safeguards that have been baked into the act at every layer, right? So PMLA is my favorite subject, and I view it like I view a piece of cake. There are layers. There's some good, there's some bad, there's frosting, there's sponge, etc. But let me get down to Vijay Madan Lal Chaudhary, right? Vijay Madan Lal Chaudhary says that the term proceeds of crime has to be construed strictly as it is one of the core ingredients constituting money laundering. All property attached or recovered by investigation agency in connection with criminal activity relating to a scheduled offense under general law cannot be regarded as proceeds of crime. So proceeds of crime again needs to be with respect to scheduled offense. That is why what Vijay Madan Lal Chaudhary says that all property attached or recovered by an investigation agency in connection with criminal activity cannot be proceeds of crime. It has to relate to a scheduled offense. But what it does is that it goes one step forward. Vijay Madan Lal Chaudhary also did something very interesting, and I found it out here because there's an illustration that is given by the Supreme Court in it. It says, to be considered as proceeds of crime, the property attached must be derived or obtained, directly or indirectly, as a result of criminal activity relating to a scheduled offense. For a better illustration, it can be said, and this illustration is very interesting, the vehicle used in the commission of a scheduled offense may be attached as property in the concerned case, that is a crime, but it will not be considered proceeds of crime within the meaning of Section 2(1) of the Act. Suppose, well, I'm not admitting to anything, but suppose I rob a bank and I use a vehicle to get away with it. It can be attached, of course, by the investigating agency under the provision of the CRPC. But under PMLA, Vijay Madan Lal Chaudhary says no, it cannot be attached. But there is a part 2 to it, because subsequently there was another judgment in the case of Padmanabhan Kishore, right? It's a criminal appeal. And the Supreme Court goes into the provisions of the PMLA quite interestingly. It is with respect to bribes. What actually happened in Padmanabhan Kishore is that a person went and gave bribe to a public servant. PMLA is invoked quite often in the case of the scheduled offense being Prevention of Corruption Act. And what they said was that if I am giving money to a public servant, the money that I'm giving to the public servant is obviously not proceeds of crime, because the crime would happen once I give the money. And once I give the money, it's not in my hands anymore. So it cannot be proceeds of crime in my hand. Supreme Court said no. And it is very interesting what they said, right? They say as long as the amount is in the hands of the bribe giver and it does not get impressed with the requisite intent and is actually handed over as a bribe, it would definitely be untainted money. So, the first defense holds true. But it says if the money is handed over without such intent, it would be mere entrustment, as if I'm going to go to a public servant and just entrust him with cash. I think that is what they meant, right? If it is thereafter appropriated by the public servant, the offence would be of misappropriation or species thereof, but certainly not of bribe. The crucial part, therefore, is the requisite intent to hand over the amount as bribe, and normally such intent must necessarily be antecedent or prior to the moment the amount is handed over. Thus, the requisite intent would always be at the core before the amount is handed over. Such intent having been entertained well before the amount is actually handed over, the person concerned would certainly be involved in the process or activity connected with proceeds of crime, including inter alia the aspects of possession or acquisition thereof. By handing over money with the intent of giving bribe, such person will be assisting or will knowingly be a party or an activity connected with the proceeds of crime. Without such active participation on the part of person concerned, the money would not assume the character of being proceeds of crime. The relevant expressions from Section 3 of the PMLA are thus wide enough to cover the role played by such person. Going back to Vijay Madan Lal Chaudhary, I would like to pose this distinguished audience with a very interesting question. The same car which I used to get away from the bank robbery, would that, in the light of Padmanabhan Kishore, be considered as proceeds of crime? According to me, if we extend that ratio, it would, because it would still be connected with the proceeds of crime. So, somehow I feel, there is a slight amount of mismatch here and there. But I think this keeps happening every time, new interesting developments keep happening. These are, interestingly, both 2022 decisions. Padmanabhan Kishore came directly after Vijay Madan Lal Chaudhary. So, the jurisprudence is evolving at a very, very rapid pace. Let's briefly get into the process of attachment and confiscation. There is obviously provisional attachment under Section 5 of the Act. Provisional attachment under Section 5 of the Act is done by the Directorate of Enforcement. It is done in order to secure the proceeds of crime so as to not frustrate the objective of this Act. The ED does not need to issue any show cause notice. It does not need to give you any prior notice. What will happen is, one fine day, there will be a Section 5(1) order passed, and it will come to you, and your property will be provisionally attached. This is very close to how we see symbolic possession under SARFAESI, or even under Benami Act, the Benami Prevention of Prohibition of Benami Transactions Act. There is symbolic possession where the actual possession doesn't go on to the person who's taking constructive possession, but the legal possession still goes with them. So when provisional attachment is done, you still get possession. However, you cannot alienate the property in any way, right? This is simply not a carte blanche for the ED. There are twin conditions. Everyone's probably heard of the twin conditions under the bail provisions, but it'd be interesting to know that, I will take the audience through the twin conditions that are there even under, on the ED for doing certain aspects. So, the Act has a lot of twin conditions to it. First is that under Section 5, there cannot be any proceeding of provisional attachment unless the director has reasons to believe. The director is obviously the Director of Enforcement or any officer authorized by him, that on the basis of his material in possession, the material in his possession, that any person is in possession of any proceeds of crime. So no provisional attachment can be done unless they believe that the person is in possession of any proceeds of crime. And two, such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime. Therefore, only having proceeds of crime is not enough. There is a second requirement also, again, as I said, a twin conditions, that there should be reasons to believe in the hands of the director, that which he has to record in writing, that such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation. So there has to be some apprehension that some third-party right may be done, or maybe that property may be taken out of India, or maybe that property is put in a place where the ED or the government of India cannot get to it. Therefore, for Section 5, both these conditions need to be fulfilled. usually when clients come to lawyers, the first thing people say is, let's go in writ. Writs are a very interesting thing. Section 5 provisional attachment writs are usually not entertained by the high courts unless you can, of course, show that uh, there are the regular procedure, the regular jurisprudence around writs, that you have to show that there is that order, that notice is completely without jurisdiction. There are a lot of issues with regards to that. Another thing is, obviously, you are put to a very, very limited sort of a disability because of this provisional attachment, simply because your actual possession is not taken away. What happens is, once a provisional attachment is done, this director has to write to the adjudicating authority, which is constituted under Section 8 of the Act. So is constituted under Section 6 of the Act, but the adjudication process is under Section 8 of the Act. And this complaint has to be given in a time-bound manner. And on receipt of this complaint, the adjudicating authority again has to apply its mind to whether the person has committed an offense under Section 3 or is in possession of proceeds of crime, right? So the first part is, obviously, the ED has to apply its mind and record reasons in writing. And under Section 8, the adjudicating authority, on receipt of the complaint, again has to give reasons in writing as to why, reasons to believe that the person has committed either an offense under Section 3 or is in possession of proceeds of crime. Yeah.
कोई कहता है मैंने 2 लाख
if the person can just be muted, please. Yes, sorry, I've done the needful. I'm so sorry about that. Section 8 is even longer than Section 5 because after adjudication, the adjudicating authority can, excuse me, yes, sorry, seems to have been one.
Yeah, I'm really sorry about that. Please.
No, don't worry about it. It happens. It's evening time. So what happens is that, of course, the adjudicating authority can either confirm the provisional attachment, or it can, after recording a finding to that effect, right, say that this is not proceeds of crime. The actual confiscation is not done by the adjudicating authority. The actual confiscation is done by the special court. Now, what is the special court? This special court is the court that is trying the offense of money laundering. Now, in Vijay Madan Lal Chaudhary, though Section 8 allows for the property possession to be taken directly after adjudication if the attachment is confirmed, Vijay Madan Lal Chaudhary, the Supreme Court cautions against this practice, because what happens is, usually when the property goes over to the government, if it is a business, if it is a bank account, if it is an actual physical property, it may not be that well maintained. And therefore, a lot of loss can come in to the person affected, especially if the special court finds that there is no, if the special court proceedings result in an acquittal. So it gets very interesting to note that, there are these inbuilt protections put in every time. And Vijay Madan Lal Chaudhary makes an observation with regards to all of these. Reasons to be recorded are very interesting for those of us who do income tax. There was a earlier section 148 of the Income Tax Act where the assessing officer had to record reasons for reopening of assessment. And then obviously the amendment happened in the Income Tax Act, and those reasons to believe are not there anymore. But reasons to believe are now in PMLA. So there are some basic facts about reasons to believe. They cannot be mechanical. The person recording the reasons to believe must actually have reasons to believe after perusing the material that is placed in front of them, right? And so on and so forth. So mechanical reasons not to be done. Under Section 8, the adjudicating authority cannot just give a rubber stamp reason to believe based on the complaint that is filed by the Directorate of Enforcement. So there is a sense of objectivity that is inbuilt into the scheme of the Act with respect to attachment and ultimate confiscation. What is the appellate procedure? What is the entire procedure? Let's just get an entire idea of this thing. The provisional attachment happens under Section 5. Section 8 is adjudication. Subsequently, appeal from adjudication goes before the appellate tribunal. From the appellate tribunal, the appeal will go back to the jurisdictional high court. It has to be noted for all my friends in Delhi that adjudicating authority and appellate tribunal are only in Delhi as we speak. So, we all have to come to y'all in case anything actually happens with respect to these two forums. But from the appellate tribunal, the appeal will go back to the High Court. And of course, whether there is an appeal or not, there's always the procedure of filing an SLP before the Supreme Court if you're not satisfied with the order of the High Court. I'm assuming everyone wants me to speak on bail with respect to PMLA because that is a fairly hot topic. It is also the main reason why PMLA is, making news. The question is very often asked, is getting bail in PMLA possible? If you actually read newspaper reports, yes, of course, it's possible in very limited cases. The constitutional validity of this has been challenged multiple times in the past. Right, there was a famous judgment by Justice Rohinton Nariman, Nikesh Tarasan Shah, in which the twin conditions were struck down, and then the Union of India made an amendment, and they said that it, revived the twin conditions. In Vijay Madan Lal Chaudhary, the constitutional validity of the reintroduced twin conditions was upheld, not only because of the amendment, but they also went out to show that a few things, they did not agree with Nikesh Tarasan Shah, and they didn't really have to go very deeply into it, though, because simply there was an amendment that was this thing. So that was a material change in the statute itself. We've had a lot of people speak a lot of things about the twin conditions. And the twin conditions are very interesting because, if I was a judge, I would find it very difficult to grant bail with respect to offenses under PMLA. Right? So I'm reading section 45, which says offenses to be cognizable and non-bailable, which says that notwithstanding anything contained in CRPC, no person accused of an offense under this act shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release. Right? So he has to be given an opportunity to oppose the application for such release. And where he opposes the application, the court is satisfied. These are the twin conditions which we're getting into now. A, that there are reasonable grounds for believing that he is not guilty of such offense, and that he is not likely to commit any offense while on bail. Now, this is the problem that most people face because we are not going to wait till evidence is led to move for bail. Usually, for those of my friends who practice criminal law, on the first date itself, when, the first order of remand, if the offense is not very serious, or even if the offense is serious for smaller offenses, you very nicely, sometimes, especially in the magistrate courts or even before the court of sessions, we write handwritten bail applications, especially for those criminal offenses that are less than 7 years maximum sentence, right? Because the Supreme Court judgment saying that below 7 years bail should be given. And if you remember, PMLA has the maximum sentence for non-NDPS related offenses is 7 years, but that doesn't apply here because there's a special act for special consideration. So what basically happens is that the judge, based on the application at that point of time, the material that is there before him, has to look into everything and come to a conclusion that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. So A sounds a bit like summary judgment to me if you have to, come to reasonable grounds for believing that he is not guilty of such offense. The word not guilty is very important. And that he is not likely to commit any offense while on bail, that means basically the judge has to be a fortune teller. He should be able to predict the future, right? And these are in addition to all the regular conditions for bail that, form the bedrock of criminal jurisprudence that has come till now. And they look quite, if you actually look at the, words, it looks quite interesting because they say not guilty. And of course, that is a very, very, very high, sort of level of conviction that a court needs to have, right? But it is, let's go one step ahead, right? There is section 17, that is search and seizure, there is section 18 that provides for search of persons, and there's section 19 that provides power to arrest. So, we'll just take a step back and go first to the power of arrest and then see whether, this not guilty is as bad. I have to give credit where due. This piece of interesting information, this insight came to me from a senior advocate. There's no court judgment that he can give. And while looking at section 19, he came up with a very, very interesting, observation. Section 19 says if the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by general or special order has on basis of material in his possession reasons to believe. Again, reasons to believe seems to be my most repeated word out here, because is there in almost 7 to 8 sections across the act. Reasons to believe, which has to be recorded in writing, that any person has been guilty of an offense punishable under this act, he may arrest such person and shall as soon may be inform him of the grounds of such arrest. This is something, if you actually read this or that, it's quite interesting, because we see a lot of remand orders where, remands are extended, where people are arrested saying that we need to investigate because there are certain things, right? Usually custodial interrogation is required. That is the primary defense that any criminal prosecutor comes up with. He says, we need custodial interrogation, therefore don't grant bail. But section 19 says that he has to, on basis of his material in his possession, have reasons to believe that any person has been guilty. That's a higher burden, not just required with respect to interrogation to establish his guilt. The word is has been guilty. Now, when we look at section 19 that says has been guilty, then the first condition or the twin condition doesn't sound that bad, because you would automatically presume that under section 19, if the director, deputy director, assistant director has information to establish that has material in his possession and a reason to believe that the accused is guilty, then only can he arrest him. And if that level of information is already there, then section 45 makes complete sense, because the court giving bail has to look into those reasons. The court giving grant that wants to grant bail has to look into those reasons, see the recorded reasons and all of it, and say, you know what, you had a belief that this person is guilty, but according to me, I have reasonable belief that he is not guilty. Unfortunately, I sometimes feel that this has been guilty of an offense under section 19, sort of gets, glossed over. And that is where the twin conditions really come into their own. Because according to me, the clear words of this section 19.1 doesn't allow you to arrest people just for custodial interrogation unless you believe that this person is guilty. What is more interesting is that reasons recorded, if they are only recorded in internal files, are completely useless. They are not justiciable unless you have copies of them. So the reasons recorded also need to establish that while arresting you, the director, deputy director, assistant director, or whoever it is that is arresting you, incidentally, Vijay Madanlal Chaudhary also says that they're not police officers, which is fine. That person should have reasons to believe that you're guilty. And only when he has reasons to believe that you're guilty, you may be arrested. And that is why one offshoot of this entire thing is that perhaps you can see that section 45(1) is not all that draconian simply because of this check and balance. Unfortunately, I don't know whether this higher standard in section 19(1) is always followed. And we haven't had too many court decisions that are very strongly, focusing on this aspect, though Vijay Madanlal Chaudhary does make a reference to it, because it says that even in arrest, there are sufficient safeguards, right? You have to be taken before the special court or judicial magistrate within 24 hours. All those things that are there for a regular accused who has been arrested are already there in your case, are already there in this case. Now, what usually happens Yes, person needs to be present in 24 hours. That is already there. Otherwise, the writ of habeas corpus will lie. Because the detention becomes illegal. That is already there in subsection three. The subsection three of section 19. Another interesting aspect that you have with respect to arrest and bail is that what happened was that under section 19(1), the wording is that he may arrest such person as soon as may be inform him of the grounds for such arrest. So what happened was different ED officers all across the country were doing different practices, right? That is there in the recent 2023 judgment in the case of Bansal, where it was observed that in certain cases, the ED officers were given written reasons. Some of them were giving oral reasons. Some of them were just showing reasons and taking this thing. And now the Supreme Court has held that you have to henceforth give those reasons. Because if you don't give reasons, how will you apply for bail? That essential safeguard goes out. And this was also very interesting because in Senthil Balaji judgment that was there again in 2023, Supreme Court, that writ of habeas corpus was put with respect to this arrest under PMLA. It says that non-compliance of any provisions would vitiate the entire arrest, which is the very basis of the criminal, law jurisprudence. Therefore, if you go to see, those written reasons need to be given to you. Now, we had very interesting aspect where, on your first day, when within 24 hours, that person is produced in front of the magistrate or the special court right now, you should then technically challenge the jurisdiction if there are any jurisdictional grounds. What is actually happening in a lot of these cases is that when you seek to claim that the arrest is illegal, forget bail for a moment, let's go back to illegal arrest. A remand comes on day one, right? At the end of 24 hours, there is a remand proceeding. You go in front of the special court on that day, and the remand is extended. Sometimes ED custody is granted. Usually, of course, even in normal cases, PC is granted once. In this case, ED custody is granted. You file a habeas corpus before a court, but it takes a few days for it to come up. By the time the matter comes up, and Delhi High Court is fantastic with respect to all these listings, but even then, what happens is the other side always takes time with respect to filing of a reply. By the time that time is given, a second remand has already happened, right? And that second remand order is not challenged in your first petition. Because when you filed the petition, there was only one remand order. You cannot challenge a remand order that is there in the future. So, it gets very interesting. There is obviously one school of thought that says if, again, in the Bansal judgment, it has been held if, first remand order itself is illegal, subsequent one also will be illegal, which is great. But this is something that can be a bit of a poser for all of us who, go to file a habeas corpus, not only in PMLA, but anywhere else, because you file this thing, what do you call it? File a writ petition for habeas corpus, and it turns out that you have not challenged certain remand proceedings. I will also get into a couple of quick things with respect to, because unfortunately PMLA is an ocean. We just have time enough for a swimming pool because we're already running short on time. I will look up some quick questions that we have with respect to interplay with IBC. I believe there was one question. Yes, interplay between IBC and PMLA, right? There are two judgments that are pending in the Supreme Court. Now, Section 32A of the IBC says that if there is any property that has been sold subsequently, 32A of IBC, which is obviously a judgment that has come, the amendment to IBC has come much later to any amendment in PMLA. So, technically, there's a Delhi High Court judgment there that says that a single bench, I think, because, let me just look it up. Section 32A, I'll just tell you. Nitin Jain, liquidator. This is a 2021 judgment, looks at with respect to Section 32A, and it considers the objectives underlying introduction of Section 32, and it goes one step forward and says that to a certain extent, the IBC will override the provisions of PMLA simply because the objective of the IBC is to actually give resolution. Now, technically in IBC cases where PMLA is involved, what happens is, it becomes pretty convoluted, because we know that in a lot of cases for PMLA right now, what actually triggers everything is a bank default by promoters. It turns out that the promoters have either siphoned off money or utilized money that they have borrowed for purposes that are not sanctioned in the loan document. And when they use that money in ways that are not sanctioned by the loan document, usually cheating comes in. Section 420 of this thing, IPC comes in, which is a scheduled offense. And a very curious things happen, because there are RBI master circulars that say that you have to, there are certain mandates upon banks now that you have to classify certain accounts as fraud if you see a fraud happening. You not only have to classify them as fraud, you also have to make sure they get prosecuted. Now, if I have a large default, which is where usually this would trigger in, say a 500 crore default, 200 crore default, I have to, as a bank, go to the police, lodge an FIR. The police will take cognizance and start investigating, which may not take time. But if this comes on the ED's radar, and it usually will, because we are talking about 200, 500,000 crores, and it's finally public money. A lot of our banks are actually public banks, right? Once it comes on the ED's radar, the fact that the money has been diverted is a scheduled offense, which triggers of the proceeds of crime. That means whatever money has been siphoned off is proceeds of crime. If that money is not available, then value equivalent, the definition which we read earlier, is proceeds of crime. So they will attach whatever property is there in the defaulting entity. That means a RP or a liquidator who's sitting on resolution suddenly has nothing to sell. And all this becomes very interesting because there is no choice on the bank not to report. They have been, they've been given the mandate. So the promoters are fighting, the bank is fighting for their money back. And the ED says, no, wait. We are attaching this. This is ours now. This will vest in the government. We will take possession of it in due course. And if you're found guilty, special court will pass an order of confiscation. This is that, reminds me of the story which we all read, where, the two cats fighting over a piece of cake. There are different variations of this. And that monkey stands with a scale. And no one gets anything. And the monkey eats everything. Not that I'm trying to say that someone is someone. But what has happened is Section 32A is an essential safeguard against that. Section 32A of the IBC says that if there is any property, where the sale has happened, right? And in fact, the finance minister in the Rajya Sabha had also said IBC has an overriding effect, right? They said that the entire idea of the IBC is to allow for resolutions to happen. If the resolution itself doesn't happen because there are no assets left with the corporate debtor, then the purpose of IBC itself is defeated. Now, usually your financial creditors are the banks. Once your banks have to complain, PMLA comes in. That is where the entire fight is happening with respect to resolution. But it is also very factual in nature. It depends upon when the provisional attachment order has been passed. It depends upon when the adjudication has happened, when the resolution has happened, when the CIRP starts, whether it goes into liquidation or not, whether it's, is sold or not. But what again happens is, just because the CD is absolved of the crime and the properties have to be let off, that doesn't mean the directors or the principal officers of the CD are let off the hook. So proceeds of crime can still be attached in their personal hands. So, with respect to Section 32A, there are a series of judgments from the Supreme Court, including Manish Kumar versus Union of India, the SPY SCC 1, where the constitutional validity of Section 32A or IBC was challenged. And it was very interesting because there were actually some discussions that happened, okay, with respect to PMLA in Manish Kumar itself, where what was said was, where the person at the time, not union, took a stand that if 32A was there, was accepted, then the money that is sought to be attached under PMLA would be let off. And at that time, Union of India has specifically taken a stand that that is the intent of the IBC. So PMLA, in the nature of an arbiter, is discussed, but the government stand is made clear on affidavit there. So it is very interesting. There are a lot of different aspects that keep popping in. Obviously, Manish Kumar, we've already been through, Manish Kumar, but then subsequently, with respect to interplay of Negotiable Instruments Act at 32A, again, P. Mohan Raj is there. P. Mohan Raj, Ghanshyam Mishra, and others. These have all looked at Section 32A and say that it has an overriding effect, right? So it is, PMLA has just started, okay? Let us not for a second even try to presume that we are anywhere seeing the light at the end of the tunnel. It is a very fast-paced field. There are a lot of questions that are still unanswered, a lot of questions that will go to the Supreme Court, a lot of questions that will go even beyond and further. But we will have to wait for the Supreme Court to come out with a lot of authoritative judgments regarding this. But what is really heartening to see is that a lot of matters have already reached the Supreme Court. So especially, the jurisprudence with respect to bail to a certain extent has been, settled now with Vijay Madan Lal Chaudhary. It is also very curious to know what will happen as and when Vijay Madan Lal Chaudhary is reviewed, and if any part of it is overturned. Because if that happens, 80% of this lecture has just been for nothing. 80% of all the decisions that have come subsequently by most of the high courts are for nothing. Because Vijay Madan Lal Chaudhary is, according to me, a dissertation on PMLA. I'll quickly, because we have a very few minutes left, let me just go through a few interesting things that Vijay Madan Lal Chaudhary. I have a cheat sheet for Vijay Madan Lal Chaudhary here because I had to write the book, right? So it was, can the ED file a complaint to the police for a scheduled offense? Right? So I'm an enforcement directorate officer and I need a scheduled offense to happen to take cognizance and file an ECIR and to start PMLA proceedings. Now, PMLA starts with the word prevention. Forget the MLA right now, but P stands for prevention. So if it's preventive in nature, I can obviously look into something, right? If a scheduled offense is not already registered by jurisdictional police or a complaint is not filed by the magistrate, it is open to the authorized officer to still proceed under Section 5, that is provisional attachment, while sending information to jurisdictional police under Section 66(2) of the Act. That's what Madan Lal Chaudhary says. So if there is no scheduled offense registered right now in the local police station, the ED officer can attach provisional attachment order because the wording of Section 5 is very wide. It doesn't need to be some, provisional attachment doesn't need to be in the hands of someone who is actually accused of the crime of money laundering. So he'll issue Section 5(1) order and then he will make a complaint to the police station. The police station will take down the FIR and he will then assume jurisdiction. It's quite interesting. Can property involved in the commission of scheduled offense be considered proceeds of crime? I already put that to you, that example of the car. What is interesting is, can possession of unaccounted money be considered proceeds of crime? Vijay Madan Lal Chaudhary says no. Possession of unaccounted property by legal means may be actionable for tax violation, yet will not be regarded as proceeds of crime unless the concerned tax legislation prescribes such violation as an offense, and such offense is included in the schedule of the 2002 Act. So suppose I have cash lying around and it's found during search and seizure in my hand. Income Tax Act is not scheduled. GST Act is not scheduled. In fact, only a few sections of Customs Act are scheduled. So if I have a pile of money at my home, it is a violation under that act, but ED cannot take cognizance unless they bring out some Prevention of Corruption Act or some other charges against me under one of the scheduled offenses, right? Can property derived indirectly be considered proceeds of crime? Yes, of course. The definition said directly or indirectly. So that has been considered by the Supreme Court. Can money laundering proceedings continue scheduled offenses quash? This was very interesting because what happened was a lot of courts had said, that the scheduled offense is required as a trigger for PMLA proceedings. But the second the PMLA proceedings start, they are standalone offenses because obviously they are different. One is investigation into the scheduled offense. Second is investigation into the PMLA activity, money laundering activity itself. Vijay Madan Lal Chaudhary said, sorry, If the scheduled offense goes, the very substratum goes. So they say that if you do not have a scheduled offense, PMLA proceedings cannot stand. So this was a major relief to a lot of people who were facing prosecution even when the FIRs were quashed. Can PMLA amendment be passed through a money bill? We still do not have an answer. The question of a money bill is in front of a constitution bench. Hopefully that will come soon. Can PMLA proceedings be taken out for those offences not in the schedule when offences took place? It is interesting because what happens is PMLA, they say proceeds of crime, the PMLA activity, the PML activity, the money laundering activity is a continuous activity. It says that the criminal activity may have been committed before the same has been notified for the purpose of 2002 Act. But if a person is indulgent or continues to directly or indirectly indulge in the proceeds of crime, he may be liable to be prosecuted for offense of money laundering under the 2002 Act for continuing to process or conceal the proceeds of crime, fully or in part, or retaining possession thereof, or will use it in tranches till exhausted. The offense of money laundering is not dependent or linked to the date on which the scheduled offense took place. The relevant date is the date on which person indulges in the process or activity connected with proceeds of crime. Is the PMLA Act preventive in nature or penal? The answer is both. Vijay Madan Lal Chaudhary says that. Can the ED take cognizance of an offense that is not scheduled? First thing, again, the ED cannot take cognizance of any offense except the offense of money laundering. If it finds during its investigation some offense has taken place, again, they will go and send information to the jurisdictional police station, which will then take cognizance of it. The ED is, if we keep the FEMA part aside, the ED is only has the jurisdiction to investigate the offense of money laundering. Can all properties of a person be attached under Section 5 of the Prevention of Money Laundering Act? Suppose the proceeds of crime in my hand that are sought to be put in my hands are only like say 5 crores. Can the ED attach 10 crores? The answer is no, only 5 odd crores. So, Vijay Madan Lal Chaudhary is a full sea of jurisprudence. We do not know how the review petition will actually pan out. A lot of things may change if it is upheld. Whether the twin conditions need to go or not is still something that is up to debate. Again, as we said, Section 19 has a very specific mandate, but I don't know whether it has been followed in word and spirit every single time when an arrest happens. We just have to wait and watch. As of today, Vijay Madan Lal Chaudhary is good law, and it is cited often and frequently. Unfortunately, this is all I can cover in the limited time I have. I've tried to cover as much as I could. I'm sorry if the whole thing didn't seem, extremely exhaustive. It couldn't have been. I had a very limited time. I've tried to give just a flavor of all that I could. I hope it has proved useful to you, because I know that every time I prepare for one of these lectures or write an article on this, I get to, re-look at those aspects of law which I haven't really seen before with respect to the same statute. With that, I thank you. Unless there are more questions. No, I think
right. So, Aditya ji, first of all, thank you so much. It was a very exhaustive and a very elaborate session, and I think as far as fundamentals could be concerned, all fundamentals, I think you very efficiently covered in this short span of time. Even though I think we were deprived a little bit of the question and answer session, considering the short period of time that you have today. But with respect to that also, I'll absolutely refrain my question, but I'll just request very humbly, because a few people actually want to ask a few questions. So if you can just entertain one or two questions as per your time, and then we can absolutely.
Sure, no problem.
So Miss Geeta Shetty, ma'am, you want to ask your question?
Sir, you can ask on behalf of me.
All right. So her question primarily is, can PMLA be said to be a white collar crime?
PMLA can be said to be a white collar crime, but it's very important to understand that the predicate of the scheduled offense doesn't need to be a white collar crime by itself, right? Because even the offense of murder is scheduled. but the schedule has a whole lot of different activities in it. A lot of statutes in it, including certain aspects of IP law. Surprisingly, when I looked at it, I was like, there are Customs Act, Transplantation of Human Organs Act, Child Labor Act. Under IPC, a lot of what do you call it? A lot of sections are covered, including with respect to kidnapping for ransom, offenses related to extortion. Now, these cannot necessarily be considered to be white collar crimes. But if any money is made off the murder, suppose we've all seen movies where someone is a assassin for hire and he gets that money, and that money is given to this nerdy person in spectacles next to him to make sure it reaches a bank account somewhere. That person can be prosecuted for money laundering, and that person will have committed a economic offense unless he's aiding and abetting. In that case, of course, 302 will be indirectly applicable to him or her.
Thank you, sir. Thank you.
I hope that answers the question, ma'am.
Thank you so much, Geeta ji. So there's this another question from Mr. Sanvay. Sanvay ji, are you here? All right, so I'll just ask his question in short. So he wants to understand what is the overlay of CRPC with the PMLA Act.
Yeah, so Section 65 says that the provisions of the CRPC shall apply insofar as they are not inconsistent with the provisions of this Act to arrest, search, seizure, attachment, confiscation, investigation, prosecution, and all of the proceedings under this Act. So CRPC will apply, but in case of a conflict, PMLA will prevail. That is across the board. There are a lot of judgments regarding a lot of safeguards that are there in CRPC. Also, there are certain things that are very interesting, that get developed because CRPC, a lot of it refers to powers of a police officer, while the officers of ED are not police officers. So, those aspects, again, wherever there is a clash, it has to be looked into the factual matrix of that case and the sections that are being involved. But generally, CRPC will apply. However, in case of a conflict, there is a non-obstante clause. The PMLA will have overriding effect.
So I think it's just fantastic how extensively you've dealt with the entire topic. And again, we've had this conversation that this is a very short scheduled time, and you have another appointment right after this. So I'll absolutely refrain from my questions for now. But I hope that in light of the fact that we've had, we're having to miss out on the opportunity to ask you questions, and considering your elaborate understanding of this topic, which is quite evident to us. So, I would most humbly request you to kindly indulge us once again in the near future with a relatively, expanding scope of time wherein we can elaborately ask questions also.
It'll be my pleasure. It's a great initiative that you're having.
It's really wonderful. It's just possible because of your kind support. Kinta sir is also back. Kinta sir, any questions, sir, with respect to PMLA that may just come across to you and which may enlighten us?
Actually, I'm very sorry because of the connectivity. I'm unable to listen to the entire lecture. And be that as it may, I'll be watching in YouTube if it is uploaded by you.
So it's most kind of you, sir. And so it's just we were just thanking Aditya ji, and we're just discussing that this initiative, it's just possible because of the likes of our seniors our colleagues, our friends at the bar, all the participants who've taken time out on a Monday evening today to make sure that something of this sort is possible in the lighter of the greater good, and hopefully for ensuring continued legal education for all. So Aditya ji, very kind of you. Thank you so much. And we wish you the best for your other engagements as well. And we've shared the link of the book. We'll try to put it in the YouTube video as well in the description of the video. So if you're watching so far, you can just find it in the description. It's very elaborate. Now you know that he's gone into the depths of the particular law. So many facets of it, I think, which people are absolutely unaware of. They will be able to learn through this video today. And we're very grateful to you, Aditya ji, for that. And we hope that we'll have this occasion of hosting you again soon.
Thank you so much.
We thank everyone who participated. We thank you for your questions, and for the questions which you weren't able to ask today, hopefully we'll get to take them up again in the near future. And with that, we seek Aditya ji's permission to end this class today. and we wish you all a very wonderful evening and a day ahead. So again, as far as the initiative is concerned, please just register for the initiative so you can get the email links, you can get the class updates, as well as please try to ensure that you're able to join the WhatsApp group so that you can keep updated with the class schedules, whatever classes are happening whensoever. And with respect to that, again, we thank you all for being participants to this humble initiative, and we're grateful to you for your kind support, because that's the only reason why we're wanting to put in this kind of effort. So with that, we seek your kind
Mr.
permission.
Keshav,
Yes, sir. Yes, sir.
Mr. Keshav, that PMLA lecture, initially when I heard, it was very nice. I could gather something. I'm having a PMLA case here in Shillong, which I got a discharge recently
Yes, sir.
because the schedule offense got discharged. So the PMLA also, ED case also we got a closure. But be that as it may, I would like you to arrange a class insofar Juvenile Justice Act is concerned, in the light of Section 75, whether a teacher disciplining a student will be can be roven for punishment under Section 75 of the JJ Act. And yes, I would like to hear again this PMLA lecture by the gentleman from Bombay High Court, I think.
Yes.
Thank you very much for that beautiful lecture. And I'll catch up with Keshav on the subject. Thank you.
That's very kind of you, sir. You're the pillar of strength, sir. All the seniors who
My
contributed
best
for the
wishes.
ministry
My
and
best
continue to
wishes.
bless us. So kind of you, sir.
Thank you.
So with respect to that, others also please just use the chat box, use it freely, send suggestions, what topics you want to hear on, any faculty specifically you want to interact with, and it'll be a privilege, it's a pleasure to be able to be of any service. तो ये सब सेवा में है, आपकी सेवा में है. हिंदी में भी कुछ करने की कोशिश करेंगे ताकि सबको समझ में आए बढ़िया तरीके से.